From item number 12 to 18.
Good. 12 to 16. What is this matter about? Adjournment. Or adjournment slip has been circulated. Sometimes in August, late before August.
25th August. From item number 21 to 27.
That's all right. You have circulated the adjournment slip, no?
Yes, yes. May I payment of the week?
That, leave it to us.
Yes.
This goes in August. Adjournment slip. Yes.
11th August.
Much more.
I wish to mention, that's why I picking item number 25.
You have also circulated this.
All right, may kindly adjourn this matter for the meeting.
For
Adjournment.
any objection?
No, I am from the opinion, date will be fixed off. Date may
Date will be fixed.
11 August.
About नीचे जाना.
All right.
May I please adjourn also?
Yes.
My lord, I beg to mention item number 26, my lord. Let PI, my lord, post back PI, my lord. My lord, learned senior counsel, Mr. Sanjay Hegde is indisposed, my lord, has recently been operated. So he has requested, my lord, to fix this matter.
Have you taken the consent of the learned advocate?
Yes, taken. I have taken the consent and informed him overnight also, my lord. So,
All right, so we keep it in August
my,
as prayed for on behalf of the petitioner and agreed to by the state. Let this matter come up for consideration August 10th.
28th August. 20.
my, deeply obsessed, all right.
From item number 28 to 30.
May I please, your lordship?
Yes.
Lordship, I beg to mention item number 21 of today's list, lordship. This is being wrongly listed before this bench, lordship.
Okay, number 21.
21.
Yes. You know, let this case go out of our list. And be placed before a bench and be listed before a bench of which one of us, bracket, Justice A.D. Chaudhary, A.D. Chaudhary J. is not a part. Place the matter before the Chief Justice in the administrative side for allocation of the court privilege.
Most obliged.
May I please your election, lordship, I beg. May I please your lordship, I beg to mention item number 28, lordship,
28 with 29.
with 29, lordship.
Any objection?
If there is a, my lord, maintain order. So, sort of like,
Very order will continue, but that,
9 August.
anyway, July after the court privilege. July.
30th July. 30.
Much.
Any other request?
May I have your lordship's permission to mention IA for direction and improvement for listing in the mining cases pertaining to Arunachal Pradesh, my lord. The matter is listed on 19 June. Now, my lord, there is some urgency because, my lord, the terms of reference under which various studies have been carried out that expires on 14th of July. But more importantly, there has been a change in law. The graphite is now comes under critical mineral. The appraisal authority is now the.
What do you want?
My lord, the
You
improvement.
remember the matter was argued by
Your
Mr.
lordship is
Krishnan.
right.
Is that
I
yes?
know, now, my lord, because the appraisal authority is the MOU, we have moved application for implement. They become a necessary party.
When do you want it to be listed?
Whenever it's
Yes,
convenient. The implement so that on 19 there is an effective hearing. Otherwise, in the absence of MOU.
The
Direction.
matter is slated to be listed on 19th of June.
My lord.
19th of June.
My lord.
Applications.
It's like 9th.
My
That
lord.
application will come on 9th of
lord.
June.
But two applications for improvement and direction. Deeply obliged.
9th of June.
Deeply.
Mention.
Daily list for orders item 1.
Come on, Lordship, the problem being that the opposite party, Lordship, is a person with disability, Your Lordship. Today he has come down, Lordship, we have signed it, we have sent you the filing today, Lordship. We have filed it today, Your Lordship, the objection, Your Lordship. I mean, Lordship will take it up on Friday, Your Lordship.
No, no, who appears for the applicant?
The applicant, Lordship, he told me this morning, Lordship, he told me it will be late, Your Lordship.
Next one.
Next, Lordship.
Next one.
10th,
Lordship.
10-6.
Right.
Item 2.
72 days already, not filed.
We have filed our objection lordship yesterday. It's the application for condonation of delay of 72 days.
Correct. Have you got the affidavit in
Hello.
response?
We received it yesterday.
We are condoning the delay. Delay condone.
Hello.
12 August. Supplementary item 31.
Maybe. This interlocutory application is for condoning the delay in preferring the appeal melody that will be passed by the Honorable Single Justice and the judgment in the review petition.
We are not inclined even to issue notice.
Lord, may I just explain, Lord?
Yes.
But the issue, the core issue which would fall for consideration, Lord, that under the Struck-Down Act, Lord, of 2011, whether benefit can be given or not.
The difficulty is that that's on merits of the case.
No, that's true.
You have to overcome this delay of 1,484 days.
But this delay includes also the delay that has elapsed during the review petition, Lord. The review was filed in 2023 and it was disposed
We
on.
will issue notice first.
Lord, I've explained the delay.
It has not been explained.
Paragraph 5 onwards. Lord.
When did you file the review?
It was filed in 2023 and there was a stay operating Lord, in the
Judgment is 21.
21. Lord, what happened Lord, in the while
We should have some material for us to condone this delay. We are very liberal in condoning it.
I understand, Lord.
Both sides.
If your lordship will kindly come to my paragraph.
Anyway, quite to hear today, we will issue notice.
Okay.
Once or date delay, notice we issue to the respondent on steps being taken by the appellants, the state of Assam and Nada, within a period of 3 weeks, both modes returnable. September 1st week.
Great to know.
7-9.
With a lot of reluctance, we have done that.
I'm
It may have a far-reaching effect, therefore, we will consider it on some other day.
very good.
We are not inclined to even issue, we were not inclined to even issue notice.
I'm highly grateful, Miller.
And we had almost dismissed it for non-prosecution yesterday when nobody had appeared.
I came to.
All right.
Great.
For admission, item 3 and 4.
Maluk, this case relates to the compassionate appointment, my lord. I applied.
Give us a minute. So we had asked for the records. Now, probably the state level committee was under the impression that the application was made in 2013, that is beyond 5 years. The fact of the matter is that the forwarding of that application was made sometimes in 2009. The death happened in 2007. Normally, we would not permit of such appointment through backdoor, even though under compassionate appointment scheme. But then he was appointed. That's the whole thing. And now with the state
Provisionally appointed.
provisionally appointed or appointed?
salary.
That we are not for regularization. You took service also from it. Now, when you say that the application was made in 2013, which is not factually correct, then it's a non-application of mine or application of mine on incorrect set of facts. Therefore, we wanted the entire record of SLC.
My lord, my colleague Sumitra Sharma informed me, my lord, she did not receive the record. The short date may be given. I will ensure the protection of the record. The state level.
Mr. Borgoya, you have a difficult case otherwise. See, the man died in 2007.
But I was appointed, I received salary also, my lord, and wrong interpretation.
Therefore, we are entering into this. We'll see whether whether there is any malafide, whether you have been deliberately kept at bay. What was the reason? Why 2013 was referred to by the state
Yes, my lord. that
scrutiny
is
committee, state level committee? You made an application sometimes in 2007 only.
7, my lord, I have annexed also. And I received a salary also for 2 months. Then for asking for my lord for approval, they said, my lord, I
There
am.
has to be some justification for, I mean, we will be commenting on Mr. Sharma, that's something else. But whether ratifying this appointment after 21 years, it'll upset the entire system. And you work for a month,
My lord,
your salary.
I worked, my lord, till last year, my lord, and salary was
You
given.
work for how many days? How many months?
I worked all along up to, my lord, 29/1/14. Sorry, my lord, I worked up
You
to
were appointed in 2021.
21. I worked, my lord,
Till what time?
till 24/7/25.
4 years.
4 years.
The single judge says that you can recover that amount from the, under the appropriate forum.
4 years I worked.
Mr. Sharma, take instructions. For the period that he has worked, at least you must pay. Take instructions on that.
And also, my lord, ensure to protect the record.
The first appointment itself is questionable. And then where, Mr. Borgoya, you have to tell us, where is the requirement dispensing with the matter to be referred to the state committee?
My lord,
No, generally, if that is a procedure, I don't think it's a correct procedure. We can't sort of allow it to pass off merely because you are, I mean, merely because the other side is what is it? Autonomous council. Unless you show that some circular which says that SLC is not to be.
no, SLC is needed, my lord, for
Then
salary part, my lord, for salary part for approval of the
why
SOE.
don't you limit your prayer, Mr. Borgoya, to the salary which was due to you for the period that you have worked? Because they took work from you. You can limit it to that.
My lord, I was working up to 4-5 years, my lord. Suddenly, my lord, while seeking time and again, my lord, authority.
Let us see the record first.
Lost it.
Thank you. Mr. D.K. Sharma, counsel for the state, submitted that the SLC records could not be obtained. Could not be obtained to be produced for the inspection of this court today. As such, a prayer for adjournment has been made on behalf of the state. Let this matter come up for consideration. August 1st week.
Published.
8 August, 5/8. Item 5 to 11.
In this case, Lordship, we have filed, I mean, I have filed person. Two IAs in two items, item number 9 and they have basically challenged the Act of 1964. We have already acquired the land, assessed, and also award has been given. What they are doing now, they are changing the character of the land in these two petitioners' case. So we want a stay order regarding or maintaining of status quo. Let the matter be heard because I think they have some prayer for adjournment. But they are changing the character, they are changing the overall situation of the land. Nature and
Who are
character.
they?
We are the petitioner. We wanted.
A legal question is involved.
Mr. AG, you have to be here.
No, yes, please.
Or you have filed the IA.
That's why I'm here, Lordship. Two IAs we have filed.
But respond to the IA and we will hear it.
Lord, in fact, we can file the rejoinder, your lordship can take up the entire.
No, IA you have to respond, not.
Yes, definitely.
But status quo may be maintained, Lordship. That order may be passed to them. Because they are keep on changing the nature and character of the land.
Let's see. Let's see the IA. One second, give us.
Lordship will kindly come to paragraph 5.
Just a minute.
Give the repetition. 6172.
617. Item 8.
There was direction from the government.
One second. How are they changing the character?
Lordship will kindly see the art filling they are studying page 13.
That you have to stop straight away.
We'll do it, Manoj.
That you like to stop because otherwise the whole purpose would be defeated.
Lord, my only prayer is, Manoj, that when Mr.
Page 12 also.
No, look at this. Since the validity of Assam Land Requisition and Acquisition Act 1964 and its purpose, that was questioned, saying that by necessary implication with the 2013 Act, it becomes obsolete. But then there is a presidential assent for the special purposes, for emergency purposes. Now, in that case, if we have directed the state not to dispossess you, then we have to also ensure that you don't change the character of it.
True, Manoj.
So therefore, we will pass that order today.
I just have two things, Manoj. According to my instruction, it has always been like this, Manoj. And secondly, Manoj, I'm led by Mr. Kane Chaudhary, Manoj. His father's death and anniversary, therefore, is a prayer meet, Manoj, at home. So
Tomorrow? Tomorrow.
No difficulty.
Otherwise, the purpose, when we protect you,
true, Manoj.
we need to protect the land also.
Yes. Look, my instruction, of course, is that it has always been like this.
Praise art filling is going on.
You mentioned some function of death anniversary. We are not passing an order today, but tomorrow. Tomorrow, Mr. Advocate.
Highly obliged, Lord.
See, this would be in continuation. It may not necessarily be in this IA. It will be a necessary adjunct of an order of stay of your disposition. It will be a continuation of that. We'll clarify that.
Perhaps we may consider.
You will have to concede, otherwise we pass the order. All right.
Right.
Tomorrow, Mr. General.
No difficulty. I am available, Lord.
As prayed for on behalf of the writ petitioners / respondent in the IA number so and so, let this matter come up for consideration on tomorrow.
Deeply obliged.
And when is the matter to be heard?
Lord, we are yet to file our rejoinder. We can file it within the week, Manoj.
The earlier the better, because a public interest project is being stalled.
You file your rejoinder also. Tomorrow we are going to pass this, that you file a rejoinder, we'll fix a date for you.
Highly applies.
May I, your lordship? Lordship, item number 7, lordship. This matter is wrongly tagged with item number 6.
We will see.
Tomorrow. Okay.
Tomorrow we'll see that.
17 to 19.
You say something. Where is Mr. Nath? Now, who is holding the brief for Mr. Nath? We don't necessarily want Mr. Nath, but somebody to assist us on that aspect. Mr. Nath had argued on the last occasion. He was representing the Social Justice and Empowerment Department. Future course of action, especially after the constitution of the new government, they were about
That the assurance was made in the November.
they were about to table a bill. Now, has it been forgotten or they are still at it? That only Mr. Nath will be able to tell you.
Lordship.
And you have not taken instructions from.
Actually, I'm appearing for the social justice department.
Yes, so you will tell let us know.
My lord, I have received some instruction from the department last night.
What is that?
Yes, they're saying that we are not the appropriate authority to take a.
Who says so? They're not. A legislation has to come.
Right.
They are not expected to pass an order which would indirectly or even directly affect the reservation. They are nobody. They are only the executing agency.
The government has just.
That is no answer.
That's why, Mr.
That's no answer, Ms. Chakravarti. That's no answer. The answer is that something was in the offing. It was required to be tabled
My lord.
in accordance with the Central Act.
My lord.
Correct.
Mhm.
So we'll see.
Because of.
And there was a
elections-
committee of Director General of Police and some other senior officers also, especially. Ms. Swati
Yes, in our,
probably referred to the special, case of reservation for women, I mean, for gender binary
Yes.
in transgenders.
I-
Requirements, the physical skill, rigor test should be different. One, they want a special reservation for this class. That is something which is in the realm of legislation. You can't do, we can't order. We can only ask.
Identifying the.
Number one. Number two, within the transgender, you have to make some distinction between male and female,
Yes, my lord. Yes, my lord.
which is a very difficult concept. Otherwise, one has to go into the very dynamics of the class. I mean, we are not equipped.
May I
The
say, my lord,
legislature
that-
will have to do it.
but it seems to be a never ending struggle for the entire community and for us as well.
That you
It
can't-
should not be, it should
you
not.
can't say like that.
No, because why I'm saying, your lordship will see to the 2019 Act, if your lordship is aware of the definition. And recently this act has got now amended again. So we have already submitted a copy of that
No,
amendment.
this is all right. First, let us see if they are about. to
The
table-
definition has itself got entirely changed.
If they are about to table that bill in the legislature, then
In
we
the
wait
st-
for it.
In the state legislature, your lordship may just refer to page 24 of PIL, main petition.
Now let Mr. Nath come. You ask him to take instructions.
Already there is a policy, state policy is there.
No, policy is not going to help. Has it helped up till now? Then policy has not helped up till now.
Yes,
And the recruitment process is over.
yes,
So it's only for future.
yes.
So why don't you ask? And the government has only only
My
recently
lord,
taken
for
over.
that reason, my lord, we are seeking.
What we do is you ask Mr. Nath to come here and cabinet. The difficulty is that there is no cabinet today.
That's the difficulty one.
I think
I think the expansion is on 5th of June.
we postpone this to August. first week of August and see what is happening. And you also ask Mr. Nath
I'll
to
take up.
take instructions. Social Justice and Empowerment Department is absolutely right in that instruction,
Yes.
that it is beyond their powers. Correct. Correct. But then in accordance with the policy, they have to come with a legislation.
State Act.
Whether they do or they don't, that is in their discretion. Because the policy says so, therefore there is a legitimate expectation that a rule would come. And otherwise, every recruitment process that you undertake,
This question.
it'll have to go through rough weather.
Yes.
Especially with this.
So that your lordship.
Correct,
will
Fasi.
just-
So let us have it on someday in August.
Yes,
August
yes,
first. Let this matter come up for consideration.
Otherwise, many of the community members are suffering. Because some of them are overaged now, some of them cross the age limit.
We can't possibly make amends to that. We will not be able to do anything with respect to this. There can't be any retrospective, corrective measure.
Yes.
Those who have lost their age will be given age relaxation. Perhaps we find ourselves to be totally incapacitated so far as this aspect is concerned. We will care for future,
Yes.
especially in these matters. But the decision-making authority is with them. Let this matter come up for consideration. Let all these matters come up for consideration on your date in August first week.
Obliged.
Obliged. 4th August. Item 20.
May I please?
Yes.
Lordship, in this case, your lordship, what has happened, your lordship, the agreed by the judgment, your lordship, at page 93 of my writ appeal, your lordship, we have came before this honorable court. The
1 second, Mr. Moore.
lord,
No, this can't be done. Who appears for the education department? Anyway, yes, Mr.
My lord,
Mr. Talgar, you have to tell us, how have you handled this matter? The court also, like single judge has gone on this aspect of the matter that his initial reappointment in 1991 was bad. But how can that be said, especially when regularization has been made? He has worked, you have given him salary till 2013,
13, your lordship.
and then you allow him to die. I mean, you literally strangulate him by cutting the salary, I mean, by stopping the salary midway. So many years, you regularized, not on our orders. This order has to go. What do you have to say? Tell us. I mean, just don't rest, just don't nod at what we are saying. We are not threatening or intimidating you, are we?
Well, it is embarrassing.
We just want to know.
Well, it is embarrassing for me to say, but Lakshmi, can you grant me some time because I have access to the records today itself, man. To go through it and if necessary.
With a condition, with a caveat, we will grant you time.
Fine.
Now, just don't be a state counsel. You're an officer of the court also.
Fine, correct.
Now, does it look fair to you?
No, I'm sorry.
Does it look fair to you? And now this lady who has come before this court, and for something which was no, and Mr. Bhattakur shows the reappointment letter.
That your lordship.
Your services should have been terminated then.
Page
There
40.
shouldn't have been any stay.
Lordship,
Correct. You did not pass your test within two attempts.
I could not, your lordship.
You could not, and
Could not.
therefore, your services were liable to be terminated. No difficulty.
No difficulty, your
But during the pendency, there was some stay order.
lordship.
Was there any direction for appointing you?
No, your lordship. There is
Nothing.
no
That
direction.
was
at all.
by virtue of a policy.
Policy, your lordship. Policy to
Now,
the
show us the 1991 reappointment letter.
lordship will kindly come to page 40. This is my application, your lordship. And then your lordship will get it at page 41. It is, I am enclosing here with an application from Maniram Patil in original. I am directed to request you kindly to appoint him in any regular post of so and so, subject to vacancy as per the office letter number so and so, since the incumbent has passed the junior basic training examination on third chance. Then
Where is that civil rule number? Let us see this order.
That your-
98989.
that your lordship will get it at your lordship. Page 36 is the or course order, not your lordship. That's page 38. This is by the Joint Director, Elementary Education, Assam, your lordship. Some problem with the translation, your lordship. I was not there in the earlier round, your lordship. Originally, it is page 39, your lordship. 39 is the original.
What is 39?
39 is the vernacular, your lordship. That's a reappointment, your lordship.
Mr. Talukdar, we are giving our introductory facts in our order today. So you respond to it. And tentatively, we are of the view that the order of the learned single judge has to be interfered with. Of course, this is a tentative view, but you have to assist the court.
Madam,
Take up.
I'm sorry for the inconvenience.
It happens every day. This side also many a times, though not in so many words, we control the proceedings, therefore we say, we put it in your mouth. But many times we have to, take time to apprise ourselves with the facts. It's a daily work, no?
Correct.
We have heard Mr. S. Bhattakur, senior advocate for the appellant, and Mr. S. K. Talukdar, standing counsel, Department of Education. A peculiar and a difficult case indeed. Next. The appellant here is the widow of one late Maniram Patel, who, despite having served as a regularized teacher, was not paid his salary from 2013 on the ground of his reappointment in the year 1991 to be invalid, and who died during the pendency of the proceedings. Hence, the widow, hence the appellant from our widow had to be substituted in his place. Late Maniram Patel was initially appointed in the year 1985 as a stipendiary teacher in a primary school. This appointment was absolutely temporary and conditional, to the extent that he was required to complete junior basic training within 2 attempts, failing which his services was liable to be terminated. Next paragraph. Unfortunately, late Patel failed in 2 attempts and his services were terminated. The termination order was questioned by Mr. Patel, by late Mr. Patel. In which an order was passed on 9/8/1988, suspending the order of termination till the final determination of the issue before the court. In the interregnum, late Mr. Patel succeeded in completing his junior basic training in his 3rd attempt. It appears that pursuant to a policy decision of the government in the education department, that all those stipendiary teachers who could not succeed in basic training course and removed from services be given reappointment if they succeed to complete the course in their 3rd attempt. The late Mr. Patel was reappointed in the year 1991. This reappointment was against a regular vacant post at Koraband Lower Primary School. He was later transferred to Bilmukh Kathalguri LP School in the year 1992. His services were regularized in the year 1995. And he was also made in charge headmaster in the year 2011. If there are any discrepancy in the facts, please let us know.
Lots.
He was made in charge headmaster in the year 2011. He continuously served thereafter, but received his salary only till October 2013. His salary was stopped from November 2013 because his reappointment in the year 1991 was held to be irregular. It was at that point of time that he had preferred WPC number 2123 of 2016, seeking release of his salary. During the pendency of the aforenoted writ petition, he died in 2017 when his wife / appellant was substituted in his place. The writ petition was dismissed on the ground that the 1991 reappointment was reappointment of the appellant, a reappointment of the late Mr. Patel was perhaps based on an interim order passed by this court, suspending the order of termination, which case got later dismissed in 1993 for non-prosecution. Hence, the appointment of late Mr. Patel had become invalid, with the interim order having been vacated with the dismissal of the writ petition. The learned single judge also held that no proper recruitment procedure was followed in accordance with 1977 provincialization rules. Thus, the learned single judge concluded that late Maniram Patel did not have any legal right to either salary or pension. The court also took note of the fact that there was some suppression regarding dismissal of an earlier civil rule. The appellant questions the aforenoted reasoning and the dismissal of the writ petition on the ground that the reappointment of late Mr. Patel was not based on any civil rule, rather on the basis of a policy decision of the state in the education department to reappoint such persons who failed in 2 attempts in obtaining junior basic training, but completed the course in the 3rd attempt. There was thus no illegality in the order, as it was pursuant to a policy decision, and there was no dispute with respect to late Mr. Patel having been appointed as a stipendiary teacher in a lower primary school, who had, in his 3rd attempt, completed the junior basic training course, though of course in his 3rd attempt. What the learned single judge, it has been argued by Mr. Borthakar, learned senior advocate, missed out was that the 1995 regularization of his service and continuous service for 27 years was a strong ground for protection of his rights. It has thus been submitted that by virtue of the court's order, a contradictory stand by the state has been ratified on perhaps an erroneous appreciation of the fact that the appointment was based on an interim order passed by this court in a writ petition which ultimately stood dismissed, and therefore the validity of the appointment of late Mr. Patel was irregular. The logic is devoid of any sense, to say the least. Mr. Talukdar London Standing Council Education Department expresses his inability to advance his arguments today for the reason of his having been entrusted with the brief only only few days ago. So he requires some more time to address this further on the issue. On his request, the matter is adjourned to next week. You can't do this. Whether you can do this or not, we will upturn this. Give a pension.
Deeply of them.
Mr. Mr. Bothakur,
Lots,
don't ask for this salary in the meanwhile.
lots,
We are not going to do that.
Lots.
Actually, benefit should be
Lots.
calculated, should be given.
lots,
Even if you ask, we will apply the same thing.
lots.
Deeply of them.
9-6.
Now you have a very limited window.
Correct.
Okay.
Yes.
Item 22 to 24.
Yes, Mr. Das.
Yes.
I'm for the Indian bank in this case, man.
You're for the Indian Bank.
Yes, I'm for the Indian bank. Earlier it was Allahabad Bank.
Now the argument has to be advanced by your,
Yes, the only point which it was admitted by division bench was only whether a mandamus can be issued by the learned single so far approximately an appointment is concerned. So only limited down there was stay. And my lord, there are after that, when I was appointed here in before a division bench, then I asked the record for what purpose?
correct. Are you taking the work from them or not?
No, they are the part-time, they will continue. There is a financial restraint is there for the bank.
No, I'm asking, please don't be on the defensive.
Yes, yes.
You may have lost in the court below. I mean,
Yes.
not in the court below before the
No,
learned
yes,
single
yes.
But then we see it with a different lens altogether.
Right, yes.
Now you started the process in 2014.
Okay, correct.
For some reason or the other, it was forestalled for the reason of a circular.
Correct,
Whether the circular applied to this process or not, this was one question before the learned single judge.
correct, right.
The circular said that for class 3, class 4, please dispense with the interview.
Right.
Now, this would have been applicable only in case where you have a written examination for recruitment and then, concluded by way of an interview. The central government circular said it was an advisory. It was not a circular. It was an advisory which said that please don't insist on interview. What class 4 and class 3 would say in interview, don't delay the process. Now you applied it here. Now
I think
forget
that-
about that.
My lord,
Now,
I,
would you be entitled? Now just listen.
right, right.
We are not.
No, correct, my lord,
We are not
please.
we are not inclined to put our imprimatur on the reasoning of the learned single judge
Right.
and the directions to conclude the interview, publish the result. We are not inclined to do that.
Yes.
But looking at it from a different angle, because it's a continuation of the reputation.
I also, you all also looked, I also thought for a moment, these are sweepers, part-time sweepers, why not?
Taking work for
Why
them.
why not a logical conclusion? Why not they should, that's what I felt, my lord. That's my view when it came to me, my lord.
The moment you stop this process can't be concluded now after 2014. What had happened, what actually happened, who all are there, who left the job, this kind of a blanket direction was not possible. Even if it is possible under 226, we in the appellate side would put some restraint on it.
Yes.
But question is that since you're taking work from them as ad hoc employees, now would you not go by what are those cases, Jago and other things and
Equal pay for them. But my lord, there is one judgment, not one, there is 4 or 5 judgments of these honorable Supreme Court. One directly, no, please, my lord, one judgment, which I think that your lordship, please go through the judgment, one judgment. One judgment of the Supreme Court, I think that will make it very clear, one judgment. Please look into the judgment.
I'll take the judgment of the sweepers.
That is secondary argument.
Yes, yes. No, that I took,
Let us,
honestly, I took the first argument while appeal was presented before the learned division bench. I took the first point that whether mandamus can be issued. That's the first point covered by judgment of Supreme Court. Then, when he was admitted, I called the bank employees. What do you want to say on it? Because 4/5/2015-16, there is a resolution which has been taken by the bank, your bank, Indian Bank. Earlier it was Allahabad Bank, where you have resolved also, so far as sweeper is concerned, that will be kept in abeyance. Sweepers also will be kept in abeyance.
right.
By resolution, my lord, when the circular, the DFS, Department of Finance Service, Government of India, has issued a circular saying that so far as sweeper will be, so far as clerical and subordinate staff is concerned, interview that will be kept in abeyance.
So, interview you have kept
Now,
in abeyance.
yes. Now, what has happened thereafter? This particular circular was circulated to all the PSAB, including the Indian Bank also. Now, Indian Bank together they decided, which I don't know whether it's a subsequently I got some record. They decided, my lord, on 4/5/2016 by the resolution by them. So far as sweeper is concerned, also that will be kept in abeyance.
Where are those?
Yes, these are not on record. That's what
Put it on,
yes, what I called it.
put it on record
Yes.
along with,
Yes,
because we will interfere to that extent,
yes,
even though it has not been decided.
Yeah.
We'll say that you're taking work from them, because this was the logic which weighed with the learned single judge.
yes.
Not primarily on the circular or its applicability, but basically on the fact that you're taking work from them. Now you would allow them to retire without regularizing themselves.
That I will, let me put this on record.
You
Let
first
me
put that on.
This is on
along with
record.
this.
Thereafter, I'll argue on the point which your lordship is asking. I'll argue on that point.
But you bring that on record.
Yes. Now, thereafter also, in pursuance to that, there is an office memorandum which has been issued in 2017, my lord. I asked them to bring all the records, which now record is with, I will bring with.
Mr. Das,
Evidence.
let us hear from Mr. Chakravarti.
Yes.
How do you defend this?
My
How do you
lord,
defend this order presently?
my lord, what I have understood, my lord, here is a case where recruitment was initiated in the year 2014 by way of an advertisement. Now, persons applied, interviews were held. Interviews were finalized.
You're aware of
Then
that still.
came this advisory. My lord, my first submission that whether this advisory can be applied retrospectively in respect of a recruitment where interviews were over. Now, if that does not apply, then the reasoning, because your lordship comes to the resolution of the bank,
Mr. Chakravarti, why to go to that? Now, suppose the entire process was over, forget about the advisory. If they abandon this program altogether, what right do you have?
yes, then things would have been different, but they have not abandoned, my lord. The thing is, they have not abandoned. Lordship may have a look at the page
They have put
96.
they have put it on hold. And in fact, with the passage of time, the whole thing has become stale. Now, could it have been revived? Something which was done in 2014, could it have been revived by a mandamus?
My lord,
That
they
is the
have,
question.
they have, my lord, they have,
Now, let me put this question to see why we ask all these questions from the council. This is not to trouble you. When we ask a question, we also reformulate our points in our mind how to decide it. That's the whole purpose of, the interaction in the court. That's the whole purpose. Don't think that we are against you or we are for you. These questions are only for firming up our opinion in the mind. Now look at it from a different point of view. Now, till the time you're appointed, till the time you're regularly appointed, do you have any right, legal right, so to say,
my lord,
of seeking a direction from the court for conclusion of the interview or for
if your lordship takes up one decision, which I have given, my lord, which says, if I apply for a recruitment process, I do not have any right for appointment.
You are
But
right to consider, yes.
I have a right for consideration in terms of the principles laid down in the advertisement. Now, here it is a case.
They have for all practical purposes abandoned it.
No, they have not abandoned, my lord. Lordship will have a look at the.
For all, why don't you hear the earlier phrase used, for all practical purposes, it has been abandoned.
There has to be a decision for abandoning it.
Mr. Das, you need to answer this.
Yes,
If it was the case, you should have withdrawn it.
Yes, I will give an answer. I've got a office memorandum. I
If your
will-
lordship looks up
My
at
lord-
page number 96, it says that it is kept in abeyance in 2016. And my lord, from 2016, they have kept it in abeyance on the basis of a circular. In my argument, my lord, that circular does not
You are
apply.
entitled to make that argument.
My lord.
But we are looking at the mandibus aspect in such situation.
So, my lord,
Could it have been corrected?
so my
Now,
lord,
we are conscious of the fact that you are all sweepers.
my lord,
And therefore you deserve to be appointed, given a regular appointment, because it's almost a perennial nature of work that you. So we are, see, instead of allowing their appeal, we are also canvassing your case. Now let us see what can be done.
I'm grateful, my lord.
My lord,
Otherwise, if we affirm this order of the learned single judge, this court's order also would not be complied with. I tell you because it will be susceptible to challenge.
My lord.
That's not going to help you.
You think, my lord, they,
Justice should be delivered.
my lord.
Case is won or not is not important
Absolutely.
to our mind.
Mr.
Das, you-
I understand what your lordship's mind.
Bring it on record.
Yes, I'll bring in record. My lord, one judgment, I'm just troubling for 2 minutes, one judgment.
Please.
One judgment of this 2020. Please see paragraph 19 at 2020 10 SCC, page 448. It's a case of recruitment. See para 19. Just para 19. 2020 10 SCC, page 448.
Yes.
See para 19, my lord, if your lordship permits, I'll just read this
Please,
para.
please.
The real issue, however, is whether the respondent are entitled to a writ of mandamus. This would depend on whether they have a vested right of appointment. Clearly, the answer to this must be negative. In Punjab versus so and so, this court held mere inclusion of candidate in a selection list does not confer upon them a vested right for appointment. The so and so committed error in proceeding on the basis the respondent got a vested right for appointment, and that could have been taken away by subsequent change in the policy. It is a settled law. Their mere inclusion of name of the candidate in the select list does not confer on such candidate any vested right to get an order of appointment. This position is maintained in para 7 of so and so. There is no select list. Only
right.
interview has taken place.
This context was something different.
Something different.
Answer key was.
No, my lord.
Selection process was-
No, what I am saying, the principle of law. Principle of law.
Principle of law depend upon in the each.
Very, I'll say what is my case and how it fits in
Your
this
case
case.
we have understood.
Yes, my case, my lord, what I say.
Therefore, you have to, Mr. Das, your argument also can run in, there are some pitfalls in your argument also. The question is this, though of course we are not totally agreeable with the order passed by the learned single judge, but you have to tell us that with all this, with the passage of time, did you recall that process?
Yes, sir.
Have you done that?
No.
No, I will.
So then aren't you keeping the, I mean, what should I, not sword hanging, but aren't you keeping the expectation alive in them?
But-
That you will conclude it someday. Question is this, you have not withdrawn it. If you have not withdrawn it, then you need to justify it.
Yes, I will.
It says the court has not given you a direction to appoint him. The court has only given you a direction to take a decision. Well, what is this keeping it in abeyance for 7 years? Now you have to
But-
look at it from different angle. Now they, with this, now suppose Mr. X were the sweeper working,
Yes,
and he
yes.
has about 10 years to go for his usual retirement. Now he would not be able to go to court seeking his regularization for the reason that this process was already afoot.
I will give an
The
answer.
process was already afoot. So therefore you conclude the process. Either you withdraw the entire exercise and say that it was under a motion which we have found that this is not the practice which we will adopt, let us resort to some other way. Against this vacancy, we will start the recruitment process. Now, there has to be some justification for keeping. This is ad hocism at its worst.
I understand, my lord, I understand that what you're.
When you say that they don't have a vested right, he's not claiming it.
Your lordship is, what his lordship is putting a question to me, that what you have done, whether you have concluded or you have intimated them about the outcome. That's
Yes.
what your lordship is asking.
Yes.
They should not remain in work for years.
Correct.
That's what your lordship is asking. If you have taken a decision, take a decision, intimate them that we are not going ahead or we are going ahead. That's what your lordship is asking me. If I'm not wrong, that's what your lordship is asking.
Absolutely. Of course, we put it in a different way. You have put it in a better way.
Not better, your lordship is.
You put it in a better way.
So we'll bring it by an affidavit before this onlook.
You bring on affidavit two things.
Yes.
Number one, there was an explanation that circular would apply.
Yes.
Number two, your justification of applying that circular to a concluded exercise.
Yes.
Two. Number three, in this case, whether he will have a legitimate expectation of being informed that the process is still continuing, it has been withdrawn, it shall never be taken up, or he will have to wait for eternity for this to be concluded. Now, something has to be done, no?
Right.
And fourth, which is the most important thing, that you're taking work from them, you will have to consider taking them into regular service. You will have to. This is ad hocism.
They are continuing with part-time.
Continuance and regular
continuing
service are
today.
different things.
If that, my lord,
Unless
the
you
whole
take-
problem,
Where-
I'll ask the bank.
Just a minute. Unless you take a decision that for all practical purposes, this would be an outsourcing. We will not appoint because of these reasons. We will not force you to.
No, that's right. My lord, if it was a DFS, Department of Finance Service, all the one-time payment is given to the banks, then absolutely no problem, my lord. Yes, my lord, I'll come with a affidavit.
Who stopped you? Indian
sorry?
Bank. Who stopped you from intimating these persons who had appeared in interview that the process is withdrawn forever? We will again take up.
Your lordship is right. Your lordship is right. I'll not say that your lordship is absolutely correct, man.
We will our introductory facts, so that on next day we don't take them. The respondents are sweepers. In various branches of the appellant bank who had appeared for interview for their services being regularized. Sometimes in the year 2014, pursuant to an advertisement issued on 29/11/2014 for appointment of full-time and part-time sweepers in various branches of the bank. The results of such interview in which the respondents had participated was not declared. It was learned later that the process was halted, perhaps for a circular / advisory from the government of India dated 22/12/2015, asking the PSUs not to go for interview for recruitment of sub-staff and clerks. A question arose before the learned single judge whether such an advisory / circular was applicable to a concluded process and whether in the present set of recruitment practice, current set of recruitment procedure evolved of only subjecting the candidates to interview and nothing else, comma, the circular would apply. The respondents reasoned that such circular was meant for such a recruitment process where after the written examination, there was a requirement for interview. In the present advertisement of 2014, comma, the only process through which candidates had to go, the only process through which the candidates had to subject themselves was to appear in an interview which exercise had already concluded. The respondents waited for several years and then approached this court by WPC number 1735 of 2020, seeking a mandamus to direct the appellant bank to conclude the process and declare the results. The writ petition was allowed by the due judgment dated 16/11/2023, directing the appellant/bank to declare the result within 4 weeks. Mr. Diganta Das, learned senior advocate, has questioned the aforenoted judgment on the ground of non-maintainability of such writ petition and possibly also on the ground of the subject matter not attracting the mandamus by a court of law for concluding an exercise which was halted because of a Government of India circular. It was argued by Mr. Das that the respondents never had any legal right to seek a writ of mandamus, directing for conclusion of the recruitment process and declaration of the result. And that the circular dated 22/12/2015, suggesting discontinuance of interviews for sub-staff and clerks in public sector banks applied to the recruitment of sweepers also, which may have been initiated in the year 2014 and interviews may have been held. But since the results were not declared, the applicability of such circular could not be questioned. Therefore, noted two arguments were refused to be entertained by the learned single judge on the ground that the circular dated 22/12/2015 was not applicable to the recruitment process of 2014, where the interviews had already been conducted by November 2015. No retrospective effect, the bench concluded, could be given to such circular. The court also expressed, the learned single judge also was at unease in recording that a public sector bank cannot be permitted to extract services from individuals without following proper rules and regulations. Every bank or any organization would be under an obligation to follow its own recruitment policy. There was also a legitimate expectation of the respondents about conclusion of the process which was initiated in 2014 and which process has yet not been recalled or abandoned or dropped. Comma, keeping the respondents in lurch for such a long time. We may also note here that all the respondents are still working with the bank as part-time sweepers. And
Perhaps not all, some are what?
some of the respondents are working as part-time sweepers. Mr. Das Leonard, senior advocate for the appellant bank, submits that he shall bring on record the clarificatory note that the circular dated 22/12/2015 applied for the appointment/recruitment of sweepers as well, and shall also indicate why the process was not totally dropped, but only kept in abeyance. Mr. Das shall also inform this court whether the appellant bank intends to start a process in accordance with its policy for giving regular appointment to the respondents on the ground that their services are needed and they have been rendering, and most of them have been rendering services in the bank in the capacity of the student. Let such an affidavit be filed by the next date. Three-three-nine-four. Okay, 3-9-4 of 2018 at 29.
No, 2018, 2020, there are three repetitions. 2018.
Earlier it was closed,
Correct.
but on a review that
We are
was
not very happy with the judgment, but we are not happy with the situation. Find out and tell us, otherwise we'll extend our. Jago Sripal and तीसरा क्या? Dharam Singh, Sripal and Jago. We will apply that and we will issue a direction. Let you question it.
But I think that with great respect, that I will not, that occasion will not come, I think. I'll try to satisfy. I'll try.
Yes, sir.
Can we? After vacation, my lord.
Therefore, we have said that the single judge was quite at unease, and therefore he directed that. You're taking work from them.
21-7.
21/7.
We are only careful that the law should not be warped under any circumstance. That's the only. But otherwise, we would have refused to interfere in these.
Can be somewhere in the month of August, my lord, first week of August. Bank, that's why it's possible.
21st of June.
First week of August.
First week of August. That's right. First week.
4th August. 4th. Item 30.
I think your lordship, so Honorable Justice Chaudhary dealt with one judgment. So far as I kept the judgment, I'll produce that judgment on the occasion when it comes, because Khadi board, I think your lordship is aware of that.
Now, if that
Mizoram
if
matter.
that judgment helps you, Mr. Das.
No, I'll say
then
that,
Mr.
that was an, that,
Then my brother will say that
That's
that was
why
sitting
I
civilly,
kept
but
it.
division bench kept it.
I kept it, me, I know, my lord, I have been, see, I have not shown, my lord. That Khadi, I think your lordship, there was an amendment which was made, whether you are permissible.
My brother is more than with me in this.
I give you option.
Item number 30. We'll come back after 5 minutes.
Item 30.
Item?
Please, Lord.
Yes.
May I please, Lord? My lord, Mr. State Appeal. In fact, it is against the judgment of the Honorable Single Judge 4/12/23. My lord, the
Just a minute, let me both who are order dated 30th of October. No, we have not followed. Mr. Talukdar, you tell us. What is required is that for becoming a teacher, for being regularized as a teacher in LP schools, they require 6 years of service. Yes. Where are you today, Mr. Talukdar? Normally, I find you to be very abreast with facts and circulars. Today, I'm seeing you in second matter. You're not very emphatic.
I'm going through the provision number four,
The provision is 4 subclause 2,
Yes.
subclause 3.
3 months.
Correct.
Correct.
So now you justify the interference by the joint committee only on the ground that it has to be seen that they have worked for 6 years. Correct. The scheme does not talk about any joint committee. The scheme talks about district level committee, state level committee. Recommendation and then done.
Finally, it was technically district.
What the single judge also has said. Now you are providing an additional information that their names were not there in the DISE code of 2011.
Which is not required.
Suppose their names are there in 2010. Now, would that mean that they have left the job in 1 year and did not continue? No, they continue. So why this joint committee has omitted to name Mr. H.R.A. Chaudhary and his clients? Why? What is the justification? Tell me. We are not suppose extra something extra than the scheme for effective implementation of the act of the purpose. Some other body also is constituted. We don't have any objection. But that body omitting the names of persons who are eligible, then that would be questioned. Why? Why do you only insist for DISE code 2011 and not 10?
My lord, my submission is, so far as my lord 910 is concerned, 3 my lord ZB, sorry, my lord 2 ZB.
Which page of this book?
My lord,
Education.
106, page by the,
107.
107.
Where is that from?
107, your lordship will come to definition, my lord, of venture LP schools, 2, my lord, ZB. Now, the honorable single judge has emphasized, my lord, on this particular aspect. Now, this reads as follows: venture lower primary school or venture LP school means a school imparting education up to class 5 and established by the people of the locality prior to 1/1/2006, whose name figure in the Dias code up to 9 and 10. So this is the requirement for a venture LP school. And prior to that, and whereof the services of the teachers have not been provincialized under any act enacted by the state legislature so far, there is a proviso, my lord, provided that Dias code shall have to be issued on or before 2019, and Dias code issued thereafter shall not be considered for the purpose of provincialization of service of any employee of the institution. So therefore, my lord, up to 2009 and 10 for the purpose of venture LP school, this has to be considered. Now, if your lordship comes to 4, 3, or 4, my lord, 4 to 2, subsection 2, clause 3. Now, if your lordship reads, my lord, the heading, teachers and tutors to be government servants. This is relatable to page, my lord, 115.
114.
This is relatable to teachers and tutors, my lord. Now, clause 3 reads as follows: must have rendered at least 6 years continuous service as on 1/1/17 from the date of joining in the concerned venture educational institution, which must be on 31/12/2010 or prior to that date. So therefore, my lord, this is the essential requirement to come to know. Yes.
So you are insisting for DISC code of 2011.
Yes.
Their names are there in 2019.
My lord,
Am
to
I
know-
right, Mr. Chaudhary?
Correct. My lord, this is a requirement to know whether
That
from.
is what we are asking for. See, they were working in the lower primary school. What is this school? Lower primary venture school.
In the tea garden.
Which school is this?
Work 5 against LP. 9 is to total. It is not.
This is lower primary, venture lower primary school or venture LP school. Now this venture LP school, all right, their names are there. Mr. Chaudhary's name is there in the DICE 2019.
Yes.
Your joint committee has rejected his name because it does not find mention in 2011 DICE.
My lord, this is for tutor continuous service.
Correct.
Yes.
So if you apply that logic, then you will have to have another DICE for 2012, third one for 2013, fourth one for 2015.
No, my lord, having found, my lord, after 2010, my lord, there was no continuous service. Therefore, my lord, they entombed.
No, that I understand, but
Yes.
this is not the prescription. That may come from their district committee has verified that he is continuing. District committee verified. Here, nobody says that the basis should be DICE. Act is not prescribed in DICE code for the calculation of this continuous 6 years.
No, but even calculation, if his name is there in the DICE code of 2009-10, how do you make out that he was not there? He has left it.
My lord,
That verification has been done. So, see, this is just a post-decisional justification by a joint committee which is not conceptualized in this scheme. And that's what the London Single Case has done. Why do we do that?
my lord, my submission is, now, since there is a dispute has arisen, my lord, it was incumbent on their part, at least, my lord, to redress the grievance before the appellate
The
authority.
logic of the dispute is non-acceptable.
My lord, 14 has not been exhausted, my lord. Your lordship will see, my lord, 14 is still there. Section 14.
Section 2.
My lord. Regarding the fact-finding committee, if it is wrong, my lord, that was a fact-finding committee. And the honorable court could not have determined on the correctness of, or otherwise, of the, my lord, findings of the, my lord, committee. That is still open to them, my lord.
That has not been exhausted, my lord, section 14.
This is against the appeal against state level scrutiny. Here, decision is taken not by the state level scrutiny.
No, Mr. Salaknath, sorry.
That exercise was done, my lord.
We have not been able to understand that distinction, of course. Dismissed.
Item 22, supplementary.
In this case, I was supposed to file an affidavit has been prepared, but it is not covering all the aspects which Lordship directed. So I'm praying for a very short date to complete the.
When do you want it to start?
Next week, Lordship, Monday or Tuesday.
No, tell me a date,
Lordship.
Mr. Fuken, you will have a copy of the
Yes.
advanced copy of that affidavit through your local counsel.
Let it be on 9th.
Right. Yeah, as prayed for by the legal advocate general, let this matter come up on 9th of June.
It will apply.
9th of
Obliged.